Hey, what's going on, YouTube? Happy Thursday to you guys, and good morning, by the way. I just wanted to do this video to talk about the Jarvis Butts hearing that happened this past Monday, and just pretty much go over the brief about what happened and what took place during the video. We heard the motions to quash, and we also heard the arguments on the discovery. So it was two issues that the prosecution not prosecution, that the defense raised. They filed two motions to quash, which was denied by the judge. Thankfully, that was a waste of paper, my personal opinion. But yeah, so the two motions to quash was denied. And then as far as the discovery, where we last left off, I believe the judge told the prosecution to have the rest of the discovery to them by Wednesday, which was yesterday. However, I do want to point out that they said they've been asking for a certain evidence and discovery since February, and it's like August going into September, which is like 6-7 months late after the fact. That right there, it can scream a lot of things. It screams unprofessionalism. It screams you're not ready to try this case for sure. It screams mistrial. It screams he could go free, or it could be a delay in his trial. It screams a lot of things when discovery is not given in a timely manner, pretty much. So what I'm going to do today is I'm going to break down what discovery is and the consequences for not having discovery in a timely manner. This is related to the Jarvis Butts and Isaiah Harris case that is expected to start in October, 2 months away. However, the defense team does not even have all their evidence or all the discovery that they need to defend their client. And I don't want him to get off. I actually want him to put under the jail. But fair is fair. And if he's not given a fair trial, even a monster like him is supposed to get a fair trial, even though we don't want him to. But fair is fair and right is right. If he's not given a fair trial, he can potentially be let go on technicality, pretty much. So I kind of wanted to discuss the discovery process and what comes with that, or what that consists of, as far as them not being, or in the state of Michigan, not having discovery in a timely manner. What could you possibly face? So I'm going to go ahead and pull that information up for you guys as well. Give me 1 second. And these are possibilities. These are hypotheticals. And none of this is concrete yet. I'm just showing you the breakdown of what discovery is, how the exchange should work between the prosecution and defense as far as giving that information to each other, and the consequences if discovery is not exchanged in a timely manner. So it's nothing, I'm not saying verbatim that this is going to happen, but it's a possibility that could raise the awareness, or raise the question of, should it be a delay? Because it can cause a delay pretty much when it comes to discovery. A defense attorney can pretty much ask for a continuance, which would cause a delay for the trial, which would push the date back. Give me 1 second. And I'm going to screen share it as well, so that way you guys can read along as I'm explaining it to you guys. Give me about a minute, folks. I'm going to go silent for a minute. I'm still here, people. I'm just trying to find the actual site. It's like every time you try to find something, it's not where you want it to be. Okay, I got the right site now. Now, there's no distinction between the federal and state system, because what I had, the link that I had up was a federal link, but I didn't want to explain into that because this is not a federal crime. This is a state crime. But there, for the record, there is no distinction between the federal and state laws as far as discovery goes. I got my window up, so you guys hear a lot of birds in the background. Apologize. Okay, I got it. So I'm about to share this link with you guys. All right, so I'm going to scroll down to where it says no, this is not the right one. Yeah, this ain't the right one. Sorry. Oh my God, this is irritating. Okay, got it. I do apologize, people. It's a rough morning, but I got the info now. Bear with me. It's like every time you put in something that you're searching for, they take it out or remove it. All right. So this is from the actual information. This is the actual information from a defense attorney here in Michigan, a well-known defense attorney here in Michigan who practiced not only federal but state crimes. Now, even though this says federal, it applies to state crimes as well too. There's no distinction when it comes to the discovery in any criminal case. So I'm going to go and read what discovery is. Discovery is loosely a synonym for evidence. In the federal criminal justice system, discovery constitutes the material in the government's possession upon which it made the determination to charge the defendant. Depending on the nature of the case, such discovery might include things like witness interviews, investigator reports, polygraph examiner reports, forensic expert reports, and other documents and records. Now, the question is the defendant entitled to everything in the government's possession? Yes and no. The rules of the criminal procedure and applicable case law require the government to turn over the discovery to the defendant's attorney for his or her review. More specifically, the government is required to produce evidence in its possession that might be categorized as Brady material, Brady material is just material that tends to exculpate the defendant, pretty much. It's just, evidence that they're holding back in so many ways, that they're not going forward with. This requirement may be memorialized in the standard discovery order. The purpose of discovery is to afford your lawyer the opportunity to bring any legal challenges about the admissibility of the government's evidence. Discovery is also used to counter the government's case and to prepare for trial. Okay. It says here, the judges in the Eastern and Western districts of Michigan will enforce the requirements of the standard discovery order very strictly. Judges are not afraid to hold the government accountable for failing to produce discovery unless the government has some valid reason. So I believe during the Monday hearing, that's why the judge was kind of questioning the prosecution as far as the why the delay, like why the time frame, because you've had X, Y, and Z amount of months, and why now? One reason often cited by the government for not providing discovery is simply the volume. And that's what we heard in Mondays in the Jarvis Butts hearing. We heard there was like several tons of data that goes back for a couple of years. And it's just like, that was pretty much their excuses as far as the why they could not give you everything, and was the amount of volume of the discovery. So, all right, so I'll continue. In some cases, there may be many thousands of pages of discovery material. Also, there may be an applicable privilege. For example, in child pornography cases, the actual images seized will not be turned over to your attorney, but will be made available for review at the office of the detective or prosecutor. Also, it should be noted that the requirement is only that the government made the discovery available for review. However, in most cases, in the Eastern and Western districts of Michigan, the government will copy any documents requested by the defendant. In the case where you have retained a private lawyer, the government will charge you for the cost of providing the discovery. Additionally, the government is required to produce any statements that you may have made during their investigation, as well as any interviews with witnesses. The government is also required to produce all documents and records subpoenaed by the grand jury. Now, when I'm saying the government, this is just this applies to state and federal. This is just what this defense attorney is speaking into, because he practices federal. But yeah, that's pretty much it. Well, that's not pretty much it, but I'm just saying I'm going to stop right there. So yeah, they are entitled to give you everything. Yes and no is what the answer was to that question. Is the state allowed or obligated to exchange over everything? And it was a yes and no. It's kind of like a gray area answer, pretty much. Now, what happens when when is the government not required to turn over their discovery materials? This is one of those instances. If a wiretap is involved, the government is not obligated to produce the wiretap itself. However, the government must provide the application for the wiretap and the records relating to that, which can be quite large. A typical wiretap application might run 100 or 200 pages. The government is also not required to produce grand jury material until after the witness has testified for the government. In the Eastern and Western districts of Michigan, it is general practice to require the protection of grand jury material prior to witness testifying. Technically speaking, though, the government has the right to refuse to do so because of what is called the Jinx Act. This act is found at 18 U.S.C. 3500 and technically prohibits the distribution of the material prior to the testimony of the witness. Okay. So for example, grand jury material is material they don't have to exchange over. So yeah. Okay, so I'm gonna pick back up. I was on mute. I'm sorry. I'm gonna pick back up right here. 1 second. Okay. So this right here would be what consists of what is considered discovery and the type of evidence that is considered discovery. The discovery process in a federal criminal case is largely controlled by Rule 16 of the Federal Rules of Criminal Procedure. According to this rule, the following information is subject to disclosure. Number 1, the substance of any oral or written statements attributed to the defendant. In the case of a written statement, the government must provide any statement in the government's custody and control or that the government lawyer, through reasonable due diligence, could know exists. This includes recorded statements a federal criminal defendant may have given before a grand jury. Number 2, a copy of the defendant's prior criminal record. So that's his rap sheet. Number one was just like any written statements or reports made that was made by the defendant, whether he said it or whether it was written down, pretty much. The government must also provide any photographs, books, papers, data, etc. within the government's control, provided this information is material to preparing a defense and or will be used by the government in its case at trial. So pictures, books, papers, any other type of data, that's also discovery. The government must also provide a written summary of any testimony that the government intends to use under Rules 702, 703, or 705 of the Federal Rules of Evidence during its case and its chief at trial. The summary must provide a description of the witness's qualifications along with a summary of their opinion and reasons for those opinions. Rule 16 also provides that the government need not provide any reports, memoranda, or other internal government documents made by a government lawyer agent for investigating or prosecuting the case. This rule also provides and sets forth the terms of reciprocal discovery. Now, this is good. What are the what are the applicable time limits for a production of discovery? So this is important. So they're basically trying to ask, when is discovery supposed to be exchanged? And this is one of the issues we had in the Jarvis Butts case. Discovery is to be provided to the defendant prior to the first pretrial conference with the district court judges assigned to the case. Then at the first pretrial, after the arraignment, the first question asked of the parties by the judge or the magistrate conducting the pretrial is, has the government complied with its discovery requirements, or the state in this matter? If the government has not, they are generally required to advise the court as to why the delay has occurred and how long will it be before they can comply with the requirements of the standing order of discovery. And that's what happened Monday at the Jarvis Butts hearing. We heard the judge ask that as well. The court will then tell the government it must produce the material by a particular date. This date will be based on a determination by the court about the exact nature of the material and the government's reason for not having it already produced. If the court feels the government's position is reasonable, it will extend the discovery period. The extension will also give your lawyer more time to file motions and possibly extend the Speedy Trial Act requirements. And that's what I wanted to get to. And that's the point I was making pretty much. In so many ways, his lawyers could, if they feel as though they're not ready with the evidence or the discovery that they're getting so late, they can possibly ask for a continuance, an extension, which would just delay the trial and push it back. Let's see, that's not. We already went over that part. What happens if discovery is not produced? If discovery is not produced as required and the government does not offer a satisfactory explanation to the court, then the court has several options. The most extreme option is outright dismissal of the case. So that's where I was getting to. It could be to a point to where the judge can easily just toss out the entire case. I don't want that to happen in this case. This case is like one of the biggest cases in the country. And we need justice for Naziah, for real. While possible, this option is rarely exercised, especially as a matter of first recourse. Instead, a district court judge would usually begin by threatening to hold the government in contempt or take some action against the AUSA assigned to the case prior to taking the more draconian measure of dismissing the case. Nevertheless, a failure to comply on behalf of the government can result in the dismissal of your case. Okay, so yeah, that was pretty much it, guys. I just wanted to break down the discovery process and what could happen if, the prosecution does not deliver this evidence in a timely manner. Even if they did, which I believe they've already done, because I think they said they had till Wednesday to exchange it. You have to realize they've given it to them 6 months later, and they're only giving them less than 2 months to review this information before the trial starts. So I don't want to wish it. I don't want to speak on it, but if the prosecution don't get it together, they could fumble this case is what I'm getting at. They could fumble this case in so many ways, and we don't want that to happen at all. So yeah, but that's all I got for you guys. I do want to say thank you. Don't forget to subscribe to the channel if you're not subscribed. Hit the like button on your way out. And that's all I got. And you guys have a great day.